Good morning, good afternoon, or good evening, everyone. Thank you so much for joining today's webinar organized by Rights and Security International and the Rights Coalition. My name is Simón Hurtado. I'm the team leader on international civic space in Rights and Security International, and with my colleagues and with distinguished panel of speakers. Thank you so much, everyone, for joining today. Without further ado, I'm going to hand over to today's moderator, Jacob Smith, Rights and Security International UK's Accountability Officer. So thank you, Jacob.
Thank you, Simon, and thanks to everyone joining us today. Just a bit of housekeeping to start with. We do have simultaneous interpretation between English and Portuguese. There will be an option at the bottom of the screen to enable that, and I think one of my colleagues will be posting in the chat some brief instructions on that if you can't figure out how to get it off the ground. The way that we'll be structuring this today, we'll have each of our speakers speak for around 10 to 15 minutes, and then there will be time for a short Q&A at the end. As Simon mentioned, I am the team leader of the UK Accountability Programme at Rights and Security International. And for those of you that don't know, RSI has for the last 30 years been advocating for governments to respect human rights, including human rights laws, when they take measures in the name of national security. This includes advocating that they effectively investigate rights violations in the national security context, including unlawful killing. And thanks also to the RISE Coalition for hosting the event. And so for those of you that are unaware, the RISE Coalition is a network of civil society organizations working at the intersection of human rights and national security from across the globe. And I think we have some of those members in attendance today, which is great to see. Just to give a bit of brief context before handing over to our panel. Unlawful killings are some of the most famous rights violations we see across the globe. While human rights laws may prohibit these acts, legal prohibitions are generally ineffective without effective and robust law enforcement bodies that are capable of investigating rights and punishing those responsible. As civil society organizations, we are in a prime position to oversee law enforcement agencies and investigations to ensure that they meet legal standards and best practices. Interestingly, we're also beginning to see an increased role for the private sector here, given that social media companies and search engines have recently come under pressure when it comes to preserving evidence and their content takedown policies. While many of these companies have been cautious in the past around allowing people to post information which could cause offence, at the same time, these posts can also be useful for law enforcement investigations. One recent example I wanted to pick up on of kind of effective civil society action comes from a couple of individual cases in the Philippines resulting from the so-called war on drugs. Now, generally, accountability in this context has been limited. Civil society pressure, both domestically and internationally, recently resulted in a former police officer being sentenced to 20 years imprisonment for killings committed last decade. So it's with that context that I want to hand off to our first speaker today, and that is Dr. Nazia Latif. Nazia is RSI's Northern Ireland advisor. Nazia worked for the Northern Ireland Human Rights Commission for 13 years, where she led a number of systemic investigations of international significance, including in defense of dignity and investigation into the human rights of older people in nursing homes. Nazia also currently runs Right Practice and specializes in providing practical assistance to organizations in the public, private and voluntary sector to initiate and manage change in order to improve the lives of all communities. And Nazia is going to be speaking to us today about some of the best practices she has experienced. So over to you, Nazia.
Thanks very much, Jacob, and thanks also to Rights and Security International for organising the event on this obviously really important topic and providing the opportunity for people to come together and learn and discuss. So I'm going to be talking about investigations into killings in Northern Ireland. So in the context of a divided and a post-conflict society, but the human rights norms that I'll be going through apply equally in all jurisdictions. So tragically in Northern Ireland, we have a long and complex history of unlawful killings. And this has been from state actors as well as non-state actors, with law enforcement agencies being responsible for and complicit in some unlawful killings, either directly or through collusion with armed paramilitary groups. In Northern Ireland, as part of the UK, we have domestic incorporation of the European Convention of Human Rights, and under Article 2 of the Convention, everyone has the right to life, and from that ensues the procedural obligation to have suspicious death effectively investigated. So what is more commonly known here as the right to an effective investigation. And in fact, it was a Northern Ireland case, Jordan versus the UK, that led to the establishment by the European Court of Human Rights of what have come to be known as the Jordan principles that outline what an effective investigation should look like. And this has very much become the benchmark for civil society organisations in monitoring investigations into unlawful deaths. That case of Pierce Jordan back in the early 90s, unfortunately, won't be unfamiliar to many communities across the globe now in 2023 in different contexts. But I'm just going to go through the circumstances of that case to set a bit of the context. On the 25th of November 1992, Pierce Jordan was shot and killed in Belfast by an officer of the Royal Ulster Constabulary, the RUC, or that was the name given to the police force of Northern Ireland at the time. And he was shot by a police officer that was named in proceedings as Sergeant A. 4 civilian witnesses stated that they saw 2 unmarked police cars force Pierce's car to the side of the road, that Pierce emerged from the car and staggered across the road, followed by the officers. And then an officer about 12 feet away fired a number of shots. But the civilians say they heard no warning given by the officers and saw nothing in Pierce Jordan's hands or anything threatening in his actions. Pierce was struck, and when the officers caught up with him, they verbally abused him. They pushed his face into the ground where he was kicked and searched. Sergeant A's statement stated that the officers believed Pierce was carrying weapons for a resupply of a terrorist organisation, that Pierce refused to pull over and his car was forced into the side of the road after a chase. He goes on to say that Pierce burst out of the car and began to run, and that he called out police, halt, or halt police. He said that Pierce spun around, he could not see Pierce's hands and feared he was armed, and he fired and Pierce fell over. Now, according to the official statement then released by the RUC, no guns, ammunition, explosives, masks or gloves were found in the car, and Pierce was in fact unarmed. The Director of Public Prosecutions found the evidence insufficient to warrant prosecution of anyone for Pierce Jordan's death. A coroner's inquest was held, and the inquest was still ongoing 8 years after Pierce Jordan's death, when his father took the case to the European Court of Human Rights. The court found that a violation of Article 2 had occurred and that there had been a failure to conduct an effective investigation into Pierce Jordan's death and the circumstances around it. And that case, as I said, led to the establishment of what have come to be known as the Jordan Principles, which outline what an effective investigation should look like. And it's important to say that these principles apply not only where there has been the use of lethal force, but also where there has been a negligent failure to protect life. So what does that effective investigation look like, and what is it that civil society organisations can use as their benchmarks? Well, firstly, the investigation should be on the state, the initiative of the state. So the state authorities must act of their own motion to initiate the investigation rather than leaving it to the next of kin to bring proceedings. So civil proceedings, even if they lead to culpability or compensation to the family, that does not satisfy the requirements of an effective investigation. The investigation also needs to be independent, so those carrying it out have to be independent from those implicated into the death, but they must also be institutionally independent and must, of course, demonstrate their independence in practice. For the investigation to be effective, it must be capable of leading to a determination of whether the action taken by state officials was justified in the circumstances and to a determination of the culpability of those responsible for the death. So this is an obligation of means rather than result. The steps taken must be sufficient to secure all the relevant evidence in relation to the death. The investigation should be prompt, so it must take place promptly after the event and must proceed with reasonable expedition. It should be transparent, and that means open to public scrutiny to a degree sufficient to provide accountability in the circumstances of the case. And the next of kin of the deceased must be involved in the investigation or the inquiry to the extent it's necessary to regard what has come to be known as their legitimate interest, and obviously that is open to some interpretation. Now, these principles don't need to be met through one single mechanism. You can have an inquest system, a prosecution, or an independent inquiry, and the principles you might know are also contained in the UN's Minnesota Protocol on the investigation of potentially unlawful death. And that's a 99-page document that details how to build the duty to investigate a potentially unlawful death. And it states very clearly about the duty to investigate promptly, effectively, and thoroughly with independence, impartiality, and transparency. And that duty applies generally during peacetime situations of internal disturbances and tensions and armed conflict. The case of Jordan versus UK, that judgment relates back to 2003. There have been 3 inquests into the death of Pierce Jordan, each one the subject of legal challenge. And 20 years later, there still has not been an effective investigation into the death of Pierce Jordan, and indeed a suite of other cases concerning the actions of law enforcement agencies dating back to the 1980s and 1990s in Northern Ireland. Those judgments are in fact subject to special supervision by the Council of Europe's Committee of Ministers. And if current proposals going through Parliament reach statute, there never will be an effective investigation, because that legislation would, in essence, lead to an amnesty of those accused of killings during the period of the Troubles, and that is for both state and non-state actors. Now, that's a rather depressing scenario to start this presentation off with. But before going on to talk about what civil society has been doing and can do, just a very quick word about the UK system. In the UK, of course, we have an inquest system, which is probably the main vehicle for addressing the Article 2 requirement. And we also have the Inquiries Act of 2015, which is flawed in many ways, but nonetheless it is there. And most notably, an inquiry is currently underway into the UK government's response to COVID. In Northern Ireland, we also have a police ombudsman, and it has been her findings that have uncovered evidence of collusion or collusive behaviours between the Northern Ireland Police Force, the RUC, and loyalist paramilitary groups. And we also have what has come to be known as a call-in facility, whereby the police service can call in an independent police team that's external to Northern Ireland to investigate killings and unlawful actions. And the biggest of these at the minute is Operation Canova. And this is an investigation team that's been led by a former chief constable of the police, John Boucher, into Republicans and state actors. And the investigation is focusing on the involvement of an alleged state agent, State Knife, who was within the unit of the IRA, and it is alleged was complicit and involved in interrogating and murdering suspected informers, all known to agents of the state. Canova is examining more than 200 murders, as well as cases of kidnappings and torture. But most recently, that state agent died. And this, of course, raises serious issues around how that particular operation will continue. Civil society organisations in Northern Ireland have had a strong role to play in advocating for the mechanisms to conduct these investigations, as well as providing evidence and expertise themselves. And it's great to have Daniel Holder here from CIJ. CIJ has been one of the leading civil society organisations in this field in Northern Ireland for a very long time. And they've done this by engaging at the national and regional level. The role of NGOs in lobbying government to bring into domestic effect the European Convention cannot be overstated. Human rights activists operating in Northern Ireland were instrumental in that. Human rights activists were also instrumental in informing the peace process in Northern Ireland. They have since provided research, briefings, and consultation responses to ensure that appropriate mechanisms are in place to conduct those investigations. And Rights and Security International, under its former name, British Irish Rights Watch, intervened in some key Article 2 cases. They've also engaged in the UN treaty monitoring bodies, and in particular the Committee on Civil and Political Rights and the Committee Against Torture. And they have engaged with the Council of Europe's Committee of Ministers, which oversees the execution of judgments of the European Court of Human Rights. And they've done this through the Rule 9 procedure, and in particular in relation to the measures in place to address the outstanding judgment in relation to Article 2 investigation. Engagement of this kind can only be effective when civil society organisations are seen as credible. And that credibility has been built up in Northern Ireland through taking an apolitical stance and always using internationally agreed human rights standards as the benchmark. And the robust analysis of existing mechanisms and outcomes and inquiries using those legal norms is key. But civil society organisations have also been strong in advocating with and on behalf of victims and their families as well, being led by the victims in work that organisations carry out, along with that work being rooted in internationally agreed norms, is of fundamental importance. But Northern Ireland has shown how very difficult it is to achieve outcomes for victims and their families. The processes in Northern Ireland have been met with underfunding, obfuscation, and outright attempts to hinder the process. And even when these different avenues are pursued and concluded, it doesn't always give families the answers that they need or want. And recently we have seen the outcomes of an approach using an interlocutor. This was a case involving a Catholic man shot dead back in 1974 by a loyalist paramilitary group, the Ulster Volunteer Force. The Crawford family went through an inquest, a criminal trial, a police ombudsman report, and a historical inquiries team report. One individual was convicted for the murder after confessing, but Mr. Crawford's son Paul said that his family secured the answers they need by talking to the UVF via an interlocutor, Winston Irvine. This was a 7-year process where the interlocutor met with the UVF, met with with Mr. Crawford's family, and in the end, the family obtained a report from the UVF on UVF, headed paper, outlining the circumstances of the death and confirming the Crawford family's suspicion that there had been collusion in the murder. And this is all more complicated by the fact that Mr. Irvine himself is currently charged with firearms offences. So, from my perspective, the legal requirements outlined by the European Court of Human Rights and by the UN guidelines are just the minimum. And even when met and culpability is identified and prosecutions are followed, the process does not always lead to satisfactory outcomes for the victim's family. So civil society organisations have a really strong role to play in holding states to account for their legal compliance, but perhaps the most complex and important role is to ensure the rights of victims' families are respected, protected and fulfilled through any process. Northern Ireland has demonstrated, I think, of all the principles, the importance of prompt investigations, so that the evidence is there and so that processes can be seen through to the satisfaction of all those that have been impacted on. And I think Northern Ireland, just in conclusion, has also shown that justice does not always reveal the truth that the families want. And of course, knowing the truth does not always lead to justice being done. And that has been a difficult circle to square here in Northern Ireland. And I think it remains a challenge for civil society organisations operating in this space. So I'll finish there, Jacob, and I'll hand over back to you, and happy to take questions at the end.
Thank you, Nazia, and very timely, I must say. You were pretty much bang on time. So yeah, thank you for the reminder, and also for those that are wanting to ask questions, please can I ask you to put them in the Q&A box. I think if they come up in the chat box, we won't be able to see them. So if they're only there, please put them in the Q&A function. I'm pleased to invite next Fausto Salvadori. So Fausto is the executive director and the co-founder of Ponte Journalismo, a journalist, been a journalist for the last 26 years, and Ponte Journalismo is a non-profit news organization covering the Brazilian criminal justice system, with an emphasis on monitoring human rights violations committed against poor and Black communities. The twice winner of the Vladimir Herzog Journalism and Human Rights Award, which I believe is the largest of its kind in Brazil. And yeah, and another important note, Ponte Journalismo is a part of the Rise Coalition, so really glad to have you here today, Fausto. So yeah, over to you.
Bom, boa tarde, bom dia a todos, dependendo do fuso horário que vocês estão. Eu queria, antes de mais nada, começar agradecendo a Rights Security International pelo convite. É uma honra e uma oportunidade imensa estar participando com vocês aqui dessa troca de ideias tão fundamental sobre um tema que é tão caro e importante para cada um de nós. Eu trouxe uma apresentação que eu gostaria de apresentar aqui, e eu preciso que alguém me autorize. Alguém pode me ajudar? Acho que agora foi. Ok. Bom, vamos começar então. Para falar, no caso do Brasil, e mesmo de muitos países da América Latina, quando se fala de violações de direitos humanos, de homicídios cometidos pelo Estado e de como fiscalizar esses homicídios, a gente tem que, antes de mais nada, falar do papel das mães. Eu queria passar as próximas. Pode seguir. Historicamente, quem costuma tomar a linha de frente na denúncia do papel do Estado como violador de direitos humanos, tanto nos períodos das ditaduras pelas quais a América Latina passou, quanto no período dos democráticos que a gente vive atualmente, na maioria da América Latina, não toda, costumam ser as mães. Tem movimentos como o das Mães da Praça de Maio, na Argentina, que se tornou a principal força de denúncia da ditadura argentina nos anos 70, e no Brasil, no período da redemocratização, quando o Estado comete violações de direitos humanos e quando o Estado elimina pessoas, na maioria delas pessoas jovens e negros, nas favelas e bairros pobres, quem costuma tomar linha de frente, denunciando esses fatos e fazendo investigações por conta própria, são as mães. Por isso que eu queria começar agora passando um vídeo de uma das mães que denunciou a morte do filho dela, a Bruna, que teve o filho Marcos Vinícius, morto em 2018. Tem um vídeo agora que eu queria passar. É o próximo slide. É isso. Próximo slide. Agora, para situar, queria explicar um pouco, dar um panorama de como está a questão da violência policial no Brasil atualmente, dos crimes de homicídio cometidos por agentes do Estado. Próximo slide. Próximo slide. O Brasil tem... anterior, desculpa. O Brasil tem um problema sério de violência policial. Todos os anos, as polícias brasileiras matam cerca de 6 mil pessoas. Para se ter uma ideia do que isso significa, os Estados Unidos, por exemplo, que também é um país que tem um problema sério de violência policial, mas que tem uma população de 330 milhões de habitantes, mata mais ou menos 1.000 pessoas por ano, né, pelas forças policiais. A gente tem uma população menor, a gente tem uma população de 220 milhões, e a gente mata 6 vezes mais do que isso. Então, é uma quantidade muito grande de pessoas mortas pelo Estado. Uma quantidade significativa dessas pessoas são adolescentes de 12 a 17 anos. No ano passado, em média, um adolescente foi morto por dia pela polícia. O impacto que a violência policial tem é tão grande que ela é responsável, em grande parte, por boa parte dos casos de homicídios do Brasil. Tem alguns estados em que as mortes pela polícia respondem por 1/3 do total de mortes violentas intencionais cometidas naquele estado. E se a polícia deixasse de matar, você teria uma queda de 1/3 no número de homicídios daquele estado. A questão racial é central para entender essas mortes. No Brasil, 56% das pessoas são negras, mas o total de mortes pela polícia é de 83% de pessoas negras. Então, existe um componente racista nas mortes pela polícia muito evidente. Próximo slide. Essa é uma declaração de um relatório da ONU feito em 2009, em que o relator traçou o panorama do problema da violência policial no Brasil. As execuções extrajudiciais estão desenfreadas em algumas partes do Brasil. Os problemas incluem as execuções cometidas por policiais de serviço, as cometidas por policiais fora de serviço, integrantes de esquadrões da morte ou de milícias, ou atuando como assassinos de aluguel, e as mortes de detentos em prisões. Vamos passar para o próximo slide. Essa situação não mudou de lá para cá. A gente continua tendo uma situação disseminada de violência praticada pela polícia, uma violência de características racistas que vitima principalmente jovens, homens, negros, moradores dos bairros pobres e periféricos das grandes cidades brasileiras. Próximo slide. Eu vou comentar agora, antes de falar do nosso trabalho,
Pastor.
de como que...
I think the interpretation channel, is it working for everyone? Iris, yes, I can hear you.
Ok. Se precisar, eu posso falar um pouco mais devagar.
1 second, sorry, Fausto.
Próximo slide. Agora eu vou explicar um pouco de como funciona o sistema de policiamento no Brasil.
How the police works in Brazil.
Se dá também a fiscalização das violações de direitos cometidos dentro desse sistema de policiamento. O Brasil tem uma organização bem peculiar de policiamento. As principais polícias estão localizadas nos estados e elas são divididas em duas. Existe uma polícia militar e uma polícia civil. Próximo slide. A polícia militar ela é encarregada do policiamento ostensivo e preventivo, o policiamento que atua nas ruas. E ela não investiga crimes. E existe uma outra polícia civil, localizada em delegacias, que faz as investigações. É uma divisão um tanto peculiar, estranha, de fato essa divisão. A polícia militar brasileira ela não é apenas uma polícia militarizada, como se fala tanto hoje no debate sobre segurança pública no mundo. Ela é mais que militarizada, ela é uma polícia militar. Os policiais militares brasileiros, eles são uma força auxiliar e reserva do Exército e eles atuam seguindo todas as normas típicas de uma força armada, com hierarquia, com divisão entre praças e oficiais, com uniformes. Então, é uma estrutura bastante militarizada mesmo. E os policiais militares são a maioria dos policiais no Brasil. O número de policiais militares é 4 vezes maior do que o de policiais civis. Então, na prática, o que você acaba tendo é um policiamento voltado muito mais para a repressão e para o controle social e para o controle racial dos mais pobres e das populações dos bairros pobres, das favelas no Brasil, do que uma polícia voltada para a investigação de crimes. Com isso, a situação das investigações acaba sendo uma situação bastante precária no Brasil. Como as polícias civis, que são as polícias encarregadas de investigar crimes, recebem menos recursos, têm menos pessoas, elas têm muito menos condições de resolver crimes. Calcula-se que mais ou menos apenas 1/3 dos homicídios cometidos no Brasil são resolvidos. Eu ainda acho essa estimativa otimista. E no caso de outros crimes, a resolução é até menor. Então, de maneira geral, crimes cometidos no Brasil têm um baixo índice de resolução. A gente vai falar dos crimes cometidos pela polícia, essa situação é ainda pior. Eu ia pedir para avançar os slides, uns 2 ou 3. Bom, vou seguindo aqui. Bom, falando isso, pode avançar pode avançar mais um pouco. Já comentei isso, pode avançar mais. Isso. No caso de homicídios dolosos cometidos pela polícia, a investigação cabe à Polícia Civil, que enfrenta todos esses problemas que eu já apontei. E a decisão se uma investigação vai se transformar em um processo judicial cabe ao Ministério Público, que é quem tem por função constitucional o controle externo da atividade policial. Porém, o que se observa e que vem sendo denunciado por vários ativistas de direitos humanos, inclusive pela Anistia Internacional, é que no Brasil o Ministério Público tem falhado muito em denunciar os crimes cometidos pela polícia. Não só porque as investigações feitas pela Polícia Civil costumam ser mal feitas, o que dificulta, de fato, o oferecimento de denúncias, mas mesmo nos casos em que há evidências abundantes de violência, o Ministério Público tende a ser omisso e não cumprir o seu papel de controlador externo, de ombudsman da atividade policial, como deveria ser. Existe uma afinidade ideológica entre Ministério Público e polícia no tocante à questão da violência. Muitos membros do Ministério Público, muitos promotores de justiça, procuradores que são membros do Ministério Público, consideram que a violência policial é parte do que se espera de um país como o Brasil. Próximo slide. Como eu tenho pouco tempo, eu ia dar um exemplo aqui, mas eu vou pular mais os slides, vou passar direto para falar do nosso trabalho na ponte jornalismo e o que a gente tem feito especificamente nessa área para fiscalizar os homicídios cometidos pelo Estado. Bom, nós somos uma entidade sem fins lucrativos que trabalha com jornalismo, entendendo o jornalismo como ferramenta de denúncia e de promoção dos direitos humanos. Então, como a gente atua? Uma das nossas missões diárias é ampliação de vozes. Então, quando a gente diz que tem várias entidades de direitos humanos, entidades de mães que denunciam a violência policial, nós fazemos muitas reportagens, documentários e livros, trazendo essas histórias que as mães, que os moradores das comunidades trazem sobre a violência policial, deixando claro que essa violência policial não atinge apenas criminosos, essa violência policial é cometida de maneira injusta e de maneira arbitrária contra jovens que não fizeram nenhum outro crime além de serem pobres e negros. Além disso, a gente faz um levantamento de provas e de testemunhos, a gente frequentemente analisa os inquéritos policiais, encontra falhas desses inquéritos e denuncia. A gente também tem um trabalho de memória, casos que são esquecidos, a gente relembra esses casos através de reportagens, de documentários e filmes. Isso muitas vezes tem consequências reais. Já teve um processo contra um jovem negro assassinado, o Leandro, e que estava esquecido há 20 anos, há 18 anos, parado. E a gente fez uma reportagem lembrando desse caso. E o caso andou, o processo foi retomado, e no final os agentes do Estado responsáveis pelo crime acabaram punidos. A gente costuma apontar muitas falhas das investigações conduzidas pela polícia. O trabalho do jornalista razoável consegue ser melhor do que o trabalho de muitos policiais, por isso a gente acaba contando muitas histórias e apontando falhas no trabalho da polícia. E a gente, ao longo desse tempo, tem conseguido algumas vitórias, como de conseguir que jovens presos injustamente por crimes fossem inocentados depois de reportagens que a gente denunciou. A gente conseguiu que agentes do Estado fossem levados à justiça por causa de denúncias que a gente fez. E atualmente, com o apoio da Rights and Security International, a gente está fazendo uma grande investigação dos dados de violência policial no Brasil, levantando quais estados têm um bom acompanhamento desses dados, quais estados escondem esses dados, e criando um ranking e um guia de boas práticas para que as autoridades públicas possam fazer um retrato mais fidedigno, mais real dos números da violência policial no Brasil. Só quando a gente souber realmente quantos a polícia está matando, a gente pode fazer uma cobrança mais adequada do Estado com relação à violência que ela exerce todos os dias junto à população brasileira.
Sorry, Pastor, I'm going to have to stop you there for reasons of time, but thank you for that really insightful discussion into your experiences, and I'm sure we can get to some of those examples that you didn't get the time to delve into in the Q&A. So it's with that we move on to our next speaker. We have Daniel Holder, the Director of the Committee on the Administration of Justice. Daniel's kindly stepped in at the last minute to cover for Paul, who's unfortunately unable to make it. CAJ is an independent non-governmental human rights organisation based in Northern Ireland, and works with international human rights standards as the framework for their work. Daniel's got a long experience in the region, so I will hand over to you now to discuss. Thanks, Daniel.
Okay, thank you. Yeah, it's a pleasure to be standing in for Paul O'Connor, who works for the Pat Finucane Centre, an NGO that's done a lot of work with individual victims in historic conflict-related cases, trying to get justice and truth in their instances. Nazia's already set out some of the background to the Northern Ireland conflict. I mean, small jurisdiction here, 1.7 million, armed conflict that ran pretty much up to the time of the Good Friday Agreement in 1998. Just to give a few more details, the protagonists were Irish Republican armed groups, British Loyalist armed groups, and then the security forces in form of both the British Army, but also the police force. And important to stress that although it was an armed conflict, it was the criminal law that applied, not international humanitarian law, not the Geneva Conventions. It was emergency law, but it was the general law that applied. In terms of the patterns of human rights violations, Nazi has already set that out in relation to state killings, both directly by the security forces and also where there were killings by paramilitary organizations, but with the collaboration or collusion of security forces or other state agents. Just to give you a sense of the scale in terms of killings in a small jurisdiction, I don't have the exact figure, but in the first few years of the conflict, for example, there were around 200 people shot dead by the military. I have the precise figures because they're rather easy to remember on the criminal justice processes applied to those. There were 0 convictions of members of the military, 0 prosecutions, and indeed 0 police investigations into the killings. So in a sense, there are similarities with the high levels of impunity that have been described in relation to Brazil. Another pattern of human rights violations that I think we can touch on today is the use of torture. Now, there was a general issue of ill treatment of detainees for serious ill treatment for confessions, but there was also the use of very specific torture techniques here, and that is laid bare briefly in a Truth Commission report, but of course not a Northern Ireland Truth Commission report because we've never had one. It is in fact in the Brazilian Truth Commission report in Dilma's government a few years ago, in the section on, I think what are called the técnicas limpias or técnicas inglesas, the English or clean techniques of torture that were taught by the British military on site in Brazil and with the representatives of the Brazilian military regime here in Belfast, in collaboration between the two states at the same time. These were the techniques that were found by the European Court of Human Rights in the Ireland versus the UK case to have breached the convention. So that's a little bit of a sense of the human rights violations that took place. I think it's important to stress that we have had significant form reform as part of our peace settlement. So that's in terms of both the police and the justice system. So in terms of how CAJ acted back in the 1980s when we were first set up, and we were trying to stop human rights violations, including state killings, as they were actually happening, it was very much a process that was focused at that stage on families and others, and the Las Madres de la Plaza de Mayo were mentioned earlier on. There were plenty of women here engaged in exactly the same work, where they gathered their own evidence as to what had just happened after a state killing, because we could not rely on the police service to do that. Therefore, whilst at that time there was very little prospect for justice, the evidence that was gathered has been extremely useful in historical cases whereby there have now been investigations as a result of processes that have grown out of the peace process. I like to tell that story in two parts. First of all, we've had the reform of the peace process. We've had reforms that have been relatively successful in ensuring not only human rights compliant policing, but strict legal rules for policing, and strict oversight and accountability bodies with teeth and with power over policing. So that having painted the pattern of what happened before the Good Friday Agreement, I can say with relative confidence now, and this is very, very rare for any jurisdiction, that there really isn't any torture here. And if the police did torture someone here, they would not get away with it. So we're in a very different situation now to what we were. There's also very little use of lethal force by the police here. We're not concerned about unlawful killings in recent times. I suppose the second part of the story is what's happened in relation to those historic cases, i.e. pre-1998, that were never investigated properly at the time. And Nazi has already gone into a lot of detail on this. What happened was CAJ and others back at that time took cases to the European Court of Human Rights to argue that those cases had not been subject to proper investigations. And that's what the European Court found, that there hadn't been independent or effective investigations, and hence the European Convention on Human Rights had been breached. Two things then happened. First of all, the Good Friday Agreement, whilst it didn't have a Truth Commission or another transitional justice mechanism, did crucially incorporate the European Convention on Human Rights into Northern Ireland law, which meant that this case law having been established at Strasbourg, that there were procedural duties to effectively investigate state killings, could now be argued and enforced in our local courts because the European Convention, because of the Good Friday Agreement, was part of our local law. What also happened was that the British government at the time, as a result of the cases, Jordan and the other cases to the European Court of Human Rights, agreed a package of measures with the Council of Europe, whereby there would be particular reforms to justice type and other mechanisms and legal and court mechanisms here, so that they were capable of discharging the duties that hadn't been discharged to conduct effective independent investigations into cases. So, for example, as a result of our peace process, we had the police ombudsman's office set up, which can and which must, in fact, investigate every discharge of a weapon by a police officer. But it was always set up as a forward-facing institution at the time. Its remit was changed after the cases to the European Court of Human Rights so that it could also examine historic cases. Within our legal system, we also have, which was also mentioned earlier, the system of inquests, which are a form of truth trials, trying to establish facts, not allocating criminal and civil responsibility. Those inquests in the past were too weak. They didn't have the right powers to effectively get to the truth in state killings. For example, they couldn't even call the soldier who had fired the fatal shots to give evidence and account for themselves. That was changed as a result of the Strasbourg judgments and the European Court of Human Rights cases. Third and final example was the prosecution service and the separation we have between, on the one hand, in our legal system, police investigations, and then decisions by the prosecution service as to whether someone will stand trial, will be charged with a particular offence. Before these cases, the prosecution service did not have to give reasons when it decided not to prosecute someone for a serious crime. So what would happen was they'd decide not to prosecute a soldier and give no reasons for doing that. That all changed with the Council of Europe decisions. The prosecution service had to give reasons, but not only that, it had to make its decisions based on a legal test. And impunity for soldiers was not part of that legal test. Therefore, if they weren't going to prosecute, they had to give a level of legitimate reasons. So we've had that package of measures in place. There are gaps in it. But what had happened since was that the UK authorities did everything within their power, and Nazia made reference to this, to restrict, thwart, obstruct, and delay the functioning of these mechanisms in legacy cases. However, families and their lawyers bit back and fought back, and they fought back using the incorporation of the European Convention of Human Rights into Northern Ireland law, so that when, for example, the ombudsman, police ombudsman, produced a report that was fundamentally flawed, wasn't independent, and wasn't effective, families went to court and had that overturned, and that it wasn't compatible with the European Convention on Human Rights standards, and the investigation had to be done again. And I think I can fairly safely predict that the last few years to date have really been the high point of historical clarification and truth recovery about state killings. So the official truth of the state, which was set out in a parliamentary command paper by the British government a year or so ago, was, quote unquote, that the vast majority of killings by the security forces were lawful. Now, the truth trials, the inquests that have taken place over the last 2 or 3 years, in the cases they have dealt with, have made findings that would highlight that the killings were in fact unjustified, i.e. were not lawful in the cases they've examined. So essentially, the official narrative is being changed. We also, to sort of finish this, had an agreement in 2014, one of the bilateral agreements of the peace settlement between the British and Irish governments and most of the political parties here, for a new suite of transitional justice mechanisms. The UK had committed right into 2020 to implement those, but along came Boris Johnson and he tore up this agreement and the treaty, and instead introduced what's now the notorious Northern Ireland Reconciliation and Information Recovery Bill, essentially an impunity bill that is going through Parliament that will provide for 3 things. One is it will completely close down everything that is currently dealing with historic cases here. So it'll close down the inquests, close down the police ombudsman's functions, close down any future prosecutions at a time they're most delivering truth recovery and historical clarification for families. So they've obviously achieved something, otherwise they wouldn't be being closed down. Secondly, it'll introduce a very broad amnesty with a very low threshold, and this was on the back of a campaign for an amnesty for the military. And thirdly, it'll set up a very weak legacy body under the direction and control of ministers. So the Empire has fought back in relation to the success that families have had over the last few years in terms of combating impunity. Just as a final point, just looking at the overall issues around that the seminar was to deal with, there was an issue around the issue of ourselves, of like NGOs, lawyers and others, and the level of interference that we would face, in particular from police spying, covert intelligence and things like that. I mean, that was a huge issue during the conflict, with now a much more strict legal framework around the use of surveillance, the use of informants, and indeed the criminal conduct of informants. So that's not really been such a huge issue for us as NGOs in recent years and lawyers. What has been a significant problem, though, is ongoing intimidation and attacks on lawyers and human rights defenders, including some earlier this week in the UK Parliament, trying to conflate lawyers with their clients and their client causes to try and demonize legal work and delegitimize it that's being done. So that remains a significant problem. I'll leave it there, Jacob, for now. That's okay.
Yeah, perfect. Thank you, Daniel. And actually that leads on nicely to our last set of speakers. So we have with us Diana Freed and Julio Poveda. Diana is a PhD candidate at Cornell University, and Julio is also a PhD candidate, but at the University of Maryland. As Daniel just mentioned, monitoring law enforcement can often create unique challenges. Law enforcement agencies in the government have many technologies they can deploy against activists and organizations that monitor their investigations for human rights violations. And they can also use some of these covertly. And so Diana and Julio are here to explain how you can all ensure that you remain digitally safe when overseeing and advocating on issues relating to law enforcement. So over to you both.
Thank you, Jacob. Simon, should we share our screen? Thanks. So, it seems I don't have the permissions. Sorry. Oh, okay, great. Thank you, Simon. Hi, everyone. Today with my colleague Diana, PhD in Information Science at Cornell University, and I, Julio Poveda, I'm a PhD student in Computer Science at the University of Maryland. We are going to share with you some digital privacy and safety tips, particular for civil society organizations. And before starting, we would also like to thank Rights and Security International for organizing this space, as well as the other panelists for sharing their thoughts and experiences. And in this part of this webinar, we have grouped our tips into 3 sections. First, we are going to talk about threat modeling. Second, we will be introducing a concept in the security domain known as defense in depth. And finally, we will focus on user education, which is very important because nowadays many attacks affect the human aspect of organizations. Let's start by talking about threat modeling. This concept refers to a process in which an individual or an organization reflects on the assets that they have, their data, their infrastructure, and also think about adversaries, which refers to malicious actors that can be outside or inside the organization who might want to steal that information, modify it, make it unavailable, etc. In other words, threat modeling is a proactive attitude or process, and it is beneficial because it helps organizations think ahead of time in which parts of their systems and data are vulnerable to cyber attacks. In this slide in particular, we are highlighting 3 questions that are important for individuals and entities to ask themselves constantly. Who is the adversary that might want to get their data or break their systems? Is this a nation-state actor, or is this a competitor, entity, or organization, or is it an insider threat, which means an employee within an organization trying to make a bad reputation of the company or entity? The second question is, what are their goals? Are they just looking to steal for their data, or do they want to lock the systems for financial gains? And third, what are their capabilities? Do they have a big budget? Are they collaborating with someone else, etc.? Asking and thinking about these questions is very important because this will inform the defense mechanisms that the company, the entity can have in order to protect their assets and information. Thanks, Simon. Now let's talk about defense in depth. On this slide, you see a castle on the left and a cube on the right. Let's start by focusing on the castle on the left. Usually, traditional castles are built with various defense rings. There are different walls, towers, etc. And this is a great illustration of the concept of defense in depth in cybersecurity. Basically, it means people cannot rely only on one defense mechanism because that is not enough. It's imperfect. And we need to rely on a series of layers of protection to protect our digital assets. Now, with respect to the cube on the right, this cube has a name. It's called the Macomber cube. And as you will see in just a few seconds, it groups various important concepts. And the reason why we're showing you this cube today is because, again, it helps people, organizations reflect on how to protect their information. Next slide, please. Thank you. So the first phase of the cube is called information security properties. And here we see confidentiality, integrity, and availability. Usually when talking about cybersecurity, people refer or mention these concepts. Confidentiality referring to you don't want everyone to be able to see your data. Integrity means you don't want everyone to be able to change it, to modify it without permission. And availability refers to you do not want hackers or malicious actors to affect the availability of the systems or information you provide to your customers. This is useful, but now let's have a look at how these information security properties relate to the other phases in this cube. Thanks, Simon. Now, this second phase of the cube is called information state. And what I want you to notice is information has different stages. It has a life cycle. Information can be stored on a computer, on a server, but information can also be transmitted between computers, or it can be processed, it can be modified. And these states relate a lot to information security properties because people can focus on or think about, okay, what am I going to do in order to guarantee the confidentiality of the information while it is being stored? Or what can I do to guarantee the confidentiality of the information while it is being transmitted? This is important because many entities only focus on just a part of this cube. For example, they just focus on confidentiality of information while it is being transmitted. But what about the confidentiality when the information is being processed and stored? Those are aspects to think about because adversaries are smart and can leverage any vulnerability in systems or companies' processes. And the last phase of this cube is called security countermeasures, which means, okay, there are a lot of problems. We want to protect our information. We want to protect our customers too. What can we do? And this phase shows or recommends us some alternatives, including technologies, policies and procedures, as well as user education. And again, something to keep in mind is that technology is one recommendation. It is not the solution. It's not perfect, it's not enough, and that's why it is good for entities to combine technological solutions as well as the good policies and practices and user education. Many companies follow a policy known as bring your own devices. And this means that they do not provide devices to their customers, but they invite their customers to use their own devices for their purposes, to work. And this is very convenient. However, we need to balance this convenience with security, because if your employees are using their personal devices to work, there are many cybersecurity risks. And for this reason, on the left, you see some considerations that your entity organization can take or think about in order to mitigate those risks. And some considerations include, for example, telling or encouraging the users to install antivirus software on those devices and scan their devices regularly. Also, lock those devices with passwords, because what if their personal devices is lost or stolen? That's a problem for the company, for the organization, because their data is also exposed. Now, Diana will talk about social media accounts and important aspects to keep in mind.
Thank you. You could add the whole slide. So looking at social media, what we'd like to emphasize first off is to establish a hard to guess password. A lot of the ways in this work that you hear that people's accounts get accessed is because a password might be something that's quite easy to guess, such as a date of birth, a name of a child. And so we always try to say that a unique hard to guess password is something that might represent a phrase and something that is very complex, using different types of symbols and logic so that it's not easy and recognizable to the individual. We also want to emphasize two-factor authentication, and I'll talk about keys and an authenticator app. And one of the things that social media has inherent in the security and privacy features are anti-harassment features, which include muting, blocking, limits, and reporting. So I'll talk about that. So if we look at social media accounts, some popular accounts here, looking at Instagram. Instagram is owned by Meta, along with WhatsApp, Facebook, and now Threads. And you can manage your security and who has access to your different accounts through the account center. So it's a management of Meta accounts. And so this is an opportunity here to select features that control what is kept private and what is kept public. There are also features offered such as muting, meaning that you're not hearing from a person who may be sending harassing, blocking an account, so blocking the individual who might be harassing. In those cases, on many of the platforms, that person will know. So for example, on Facebook, if you block someone and they search your name or you search their name, they will not appear. And your personal profile will not appear in a direct search. And there are also different types of privacy features offered, such as keeping your personal profile private, tagging options in photos by which you can select that feature to make sure that a photo is not posted with your identifiable name on it and that you have to approve that photo first. In TikTok, there are other features here that we just like to emphasize. They also, every type of social media account will have different types of security and privacy features. So making sure that you have certain features off, such as duets or stitching accounts together. By turning those off, what happens is if you post a video on those sites, it prohibits another user from using the content that you've provided to that platform and creating a video alongside of your video, and to perhaps, with a bad actor, misrepresent the intention of your initial video. And we provide here some useful resources for Instagram, TikTok, and YouTube to access more of these features directly. Next slide. So in terms of keeping accounts secure, one option is 2FA, which is two-factor authentication, which is effective, but as Julio mentioned earlier, sometimes we need more than just one aspect of protection. And so here we're also suggesting the consideration of authentication apps. An app that is helpful is an app like Duo Mobile. And so when you're logging on, you'll get the kind of alert here that you see that goes directly to the phone. This is an application that is directly put on your personal device, and you can approve or deny and be notified of any time your personal account is notified. So it's an additional mechanism by which to protect your account should someone try to bypass two-factor authentication. Next slide. But two-factor authentication is also inherent within many accounts. You'll be asked to prompt it, and it is something that can be used easily to activate, for example, two-factor authentication on Google. It's very simple. You go to your account settings, you look for an option called security and privacy, and then begin the two-factor authentication process here to set it up. And so that every time that you are logging on, you can either get notified through an alert to a phone or through a Google Authenticator app, which will alert you through one of your devices. So it's just making sure where that goes when setting it up and really checking, who has access to your accounts and where authentication goes directly. But this will allow for notification when accounts are accessed.
Thanks, Diana. Let's keep talking about two-factor authentication. So as Diana said, it's a great security protection for people's accounts because it doesn't matter if the adversary or the hacker guesses or knows the password, they will not be able to get that information immediately because they will be prompted for a security code that is generated by the Authenticator app, for example. In the security community, there is a more safe way of providing that security code. And this is what hardware security keys come into play. This image on the left shows two sample security keys. They look like USB sticks. And basically, instead of checking your Authenticator app and typing the code when prompted, you would just have to plug one of those devices into your computer when you're trying to sign in. And this has many security researchers and practitioners believe and state that this is more secure than using or receiving security codes via SMS or via an Authenticator app. And on the right, you see two QR codes that we invite you to scan. The one on the top will show you the applications online accounts that are compatible with hardware security keys, because sometimes people are concerned about, I'm not sure because what if the application or online account I use is not compatible with these devices? But there's a lot of compatibility right now. And the QR code on the left will take you to a page where you can buy these devices and compare prices because there are different models. Now let's talk about emails. We use emails every day, and it's important to take some ideas into account. In this diagram, on the left, you see someone that is going to send an email, a sender, and on the right, you see someone that will receive the email, the recipient. And this email is transmitted over the internet. I want you to notice the following. In this example, both users, both of these individuals are using the same email provider, let's say Gmail. So both are using Gmail. And this is good in this situation because as the sender and the recipient are using Gmail, then probably when this message is transmitted, it will be encrypted. And not only that, it will be encrypted with a good encryption scheme, the same encryption scheme. But what happens in the following scenario? Next slide, please. Thank you. In this case, the sender has the email provider A, and the recipient has a different email service provider. Some problems might appear here because these different email providers might not be able or might not share the same encryption scheme, what is used to hide the content of the email while it is being transmitted. So this is problematic because in this scheme, end-to-end encryption, which means the email is hidden, encrypted from the sender to recipient, end-to-end encryption might not be guaranteed because the sender and the recipient do not have the same email provider. So these are some considerations to keep in mind. And in addition, by default, the email services providers that people commonly use, these providers gather information from the users, and they also gather some metadata from the emails. And this can be problematic in sensitive contexts, like the ones that we've been talking about. For this reason, today we also wanted to mention that there are other email providers, there are alternatives, and they are more privacy preserving in the sense that they have different encryption schemes to guarantee end-to-end encryption. And in addition, they try not to gather a lot of data from the users. And one example of this is Proton Mail. Before moving to the next slide, I also want to mention the following. Sometimes employees use one phone, their personal phone, for their working purposes. So they access the working email on their personal phone because of convenience. This can be an issue too, for many reasons. So another good practice is to separate the use of devices. In other words, have one device or encourage your employees to have one device for personal uses and one device for working purposes. So separate devices and also separate accounts. Why? Because when you start using the same device or the same account for your personal usage and for working purposes, then something known as fingerprinting can occur. And fingerprinting means someone might try to track you and also log and determine all your activity on your accounts and devices. So to avoid this, you can use one device for personal purposes, one device for working purposes, and also accounts for personal usage and accounts for working purposes.
So sorry, Julio, I'm going to have to cut you off there just because of timing, but we can certainly see if participants can get access to these slides through Eventbrite for bits that have been missed. But yeah, so sorry to cut you off there and what is a very important discussion. I want to now skip on to the Q&A. I've had a couple of questions directed to me, and we have one in the chat as well. First question, I've got one for Fausto. Could you please explain the role of the Inter-American Human Rights Court in dealing with cases of human rights violations committed by police in Brazil, and if any of the court's judgments have helped victims or groups in Brazil to access justice? So that one's for you there, Fausto.
A Corte Interamericana de Direitos Humanos tem sido recurso bem importante para os ativistas que trabalham no Brasil. Para começar, a gente, com o final da ditadura, tivemos uma experiência de justiça de transição que foi pela metade. A gente teve apenas uma comissão da verdade que apontou os crimes cometidos pela ditadura, mas houve uma lei de anistia que impediu que esses crimes fossem punidos. Esse foi um caso, por exemplo, que foi julgado pela Corte Interamericana de Direitos Humanos, que já apontou que o Brasil falhou nesse ponto. O Brasil precisa sim punir os crimes cometidos pela ditadura. Houve vários casos que foram levados à Corte, e a Corte já decidiu que crimes cometidos por policiais que não foram devidamente julgados deveriam ser reabertos. Isso já aconteceu, mas isso esbarra em muitas questões. Uma delas é a dificuldade. O Brasil faz parte do sistema de direitos humanos, e as autoridades buscam seguir essas determinações, mas tudo costuma ser aplicado de maneira muito lenta e demora a que efetivamente seja aplicado. O Brasil não desobedece às determinações da Corte Interamericana de Direitos Humanos. Em tese, o Brasil está seguindo essas determinações, mas tudo acontece de maneira tão lenta que fica difícil você perceber isso sendo efetivamente aplicado. O exemplo dos crimes cometidos pela ditadura é um deles. Até hoje não foram punidos e não há uma movimentação clara para que isso aconteça. Tem um caso de sucesso interessante em que a Corte Interamericana de Direitos Humanos julgou o caso de uma mulher que foi agredida pelo seu companheiro a ponto de ter danos físicos permanentes. Isso levou o Brasil a sofrer uma condenação da Corte Interamericana de Direitos Humanos, e o Brasil criou uma lei contra a violência doméstica que se mostrou bastante efetiva, não tanto pela punição em si, mas porque essa lei criou as figuras das medidas protetivas, em que qualquer mulher ameaçada pode pedir o afastamento do companheiro imediato. Isso foi uma mudança bastante real, isso salvou a vida de diversas mulheres e foi, de fato, uma influência direta de uma decisão da Corte Interamericana de Direitos Humanos. Mas, no geral, especialmente quando se trata de punir agressões cometidas pelo Estado, o Brasil é bastante lento ao aplicar as decisões da Corte Interamericana de Direitos Humanos.
Thank you for that. That's a really interesting response. We've also got a question, and probably be the only other question we can get to for Daniel, just asking about the possibility for a new interstate case brought by the Irish government against the British government if the legacy bill were to become law, and also to get your view on the prospects of success. So Daniel, and then maybe Nazia could feed in some thoughts to that as well.
Sure, yeah. I mean, the Irish government's official line is that the taking of another interstate case, so another Ireland versus the UK against the legacy bill, is something that's under active consideration, and hopefully they will do it. There will be lots of litigation in the local courts by victims when the bill goes through. Problem is, that's important, but it could take quite a long time before it goes through the various stages of appeal. The state will no doubt appeal. We don't need to delay the bill for that long, though, because hopefully there will be a change in British government that will take a very different position to this one. The advantage of the Irish government taking an interstate case is that they can get this straight before the European Court of Human Rights without having to exhaust the domestic legal processes. So it can be done more quickly. They could also ask under Rule 39 of the court for interim measures, i.e. that the state can't commence some of the aspects of the legacy bill until the court has had the chance to hear the case. In terms of its prospects of success, every expert and position holder within the Council of Europe human rights system and the relevant offices within the UN special procedures have all made very strong statements that this bill is not compatible with either UN treaties or the ECHR, so there are very strong prospects of success in that sense.
Thanks, Daniel. And Nazia, was there anything you wanted to add to that?
No, I think Daniel's absolutely correct in terms of the Council of Europe and the various UN special rapporteurs in this field haven't held back in being critical of the bill and its incompatibility with human rights norms. But the government is moving very fast. They've already appointed a head of the commission that's been set up. They've just today advertised for 4 non-executive commissions to take on that role. So civil society finds itself in a real dilemma here in terms of what do we play ball? Do we try and mitigate against the worst aspects of that and engage with that commission when it's set up to try and get something as opposed to nothing? Or, do we take, that purist and principle stance and said, no, we're just not engaging at all, and we'll see how things play out in the courts. So I mean, Northern Ireland finds itself in difficult times, to say the least.
Thank you both. And so it's with that unfortunately we come to the end of the webinar today. Thanks to all the panelists for what was a really insightful and insightful discussion. And we heard from Nadia about the Jordan principles for effective investigations from the European Court of Human Rights. And she also gave some practical examples from the Northern Ireland context, which, although some of these are historical, still have yet to have been effectively investigated. She also spoke about the range of mechanisms currently in place, both in and outside Northern Ireland, that are available for civil society groups to engage in advocacy, and spoke about the importance of using human rights frameworks to attach advocacy in what is otherwise a contested environment. We heard from Fausto about the systemic issue of police brutality and unlawful killings in Brazil, and particularly the racial component to that issue. He also spoke about the role of women, and particularly mothers, in South American advocacy on this issue. Additionally, Fausto highlighted the lack of independence with the investigations into alleged police brutality and killings, as well as the perceived bias in proceedings against the police. He also spoke well about the role of journalism in bringing stories of violence to light. We also heard from Daniel about his experience of working in the Northern Ireland context and the experience of CAJ also, and the lack of accountability to date for some of the unlawful killings, torture, and ill-treatment in that context. He touched on some of the troubling and close similarities between the Northern Ireland and Brazilian contexts in the methods that the UK used in Northern Ireland, subsequently being taken up by Brazilian officers. He also outlined some of the similarities in how advocacy has been led by the people in many instances, collecting evidence about alleged crimes and rights violations, but they have also been able to directly rely on human rights frameworks to ensure that investigative mechanisms complete their roles more thoroughly. And finally, we heard from Diana Curio about some digital security tips for advocates when engaging in investigations. And they gave some practical advice on modelling threats from the outset of the work and advising on how to protect the information that we may hold, whether that's our information, our partners' information, clients, or service users. So it's with that I'll bring this to a close. Thanks again to our speakers for sharing their insights. Thanks to Rise Coalition and Rights and Security International for hosting the event, and thanks to all our attendees.